Good afternoon, ladies and gentlemen. Welcome to the SIAC-THAC webinar titled, Is There a Right to a Physical Hearing in International Arbitration? My name is Suen, SIAC's Business Development Manager Legal, and I'm pleased to be your MC. I'm very excited to introduce you to our panelists today who will be sharing their perspectives on the topic as well as the position in various jurisdictions. They are Mr. Parayappo Kamalsip, Partner and Co-Head of Dispute Resolution, Litigation, and Arbitration Practice of Kudun and Partners. Mr. Prin Laumanutsak, Associate of DLA Piper Thailand Limited. Dr. Lars Market, Partner of Nishimura and Asahi. Mr. Kabir Singh, Partner of Clifford and Chance. Ms. Carrie Stan, Partner of Peter and Kim. Moderating today's session is Mr. Varathon Wongsa Wangsiri, Member of YSIC Committee and Partner of Herbert Smith Freehills Thailand Limited. If you have any questions, please send them through using the Q&A function, and our panelists will try their very best to address as many questions as possible. And if you're applying for CPD points, please ensure that you remain logged on for the entire session. Without further ado, I will now pass the time to Varathon. Thank you.
Swadikap. Good afternoon, everyone, and greetings from Bangkok, Thailand. Welcome to the SIAC-THAC webinar titled, Is There a Right to Physical Hearing in International Arbitration? My name is Varathon Wongsawangsiri, a partner of Herbert Smith Freehills in Bangkok. I will be the moderator of this panel. Since the start of COVID-19 pandemic, there is the issue whether there is a right to a physical hearing in international arbitration at the time when virtual hearing are serious consideration by tribunals and parties involved to ensure the continuation of arbitration proceedings. This is an interesting topic on which we will discuss. I would like to start with introducing our honorable speaker. Firstly, let me introduce the only female panelist today, Carrie Stan. Carrie is a partner at Peter and Kim, and a Thai qualified Singapore, English, England and Wales, and New York. She specializes in international commercial and investor state arbitration and public international law. She has represented clients as counsel and has been appointed as an arbitrator in both international arbitration and state-to-state dispute. Carrie has been recommended by Asia Pacific Legal 500 for international arbitration and named as a future leader in arbitration by Who and Who Legal and GR. Welcome, Carrie, for today. Next, La Market. La is a partner in Nishimura Asahi International Dispute Resolution Department in Tokyo, Japan. He represents clients in international contentious proceedings involving post-M&A, commercial, construction, and distribution matters. Lars also acts as an arbitrator. He has specific experience with cases involving governments and has advised foreign investors and states on issues of foreign direct investments and public international law. Lars is regularly recommended in legal directories such as Chambers and Who and Who Legal. Welcome, Lars, for today. Next, Kabir Singh. Kabir is a partner in the International Arbitration and Dispute Resolution Practice of Clifford Chance, based in Singapore. He specializes in complex cross-border dispute with focus on India, Indonesia, and Southeast Asia. His clients include large multinational corporations, international banks, and financial institutions which present across Asia Pacific. He is a market leader and is regularly ranked by leading international legal directories such as Legal 500, Chamber and Partner, and Who Legal. Welcome, Kabir. Next, Kun Pariyapon Kamonsin. Kun Pariyapon is a partner and co-head of dispute resolution and litigation practice of Kudun and Partners. His expertise spans across a wide range of industry, including engineering, construction, steel, mining, energy and power generation, and telecommunication. He was named as recommended lawyer in dispute resolution by Legal 500 Asia Pacific 2020 and a litigation future leader by Who and Who Legal. He is a rising star among practitioners in Thailand now. welcome คุณปริยพล last but not least คุณปินเหลามนัสศักดิ์ of DLA Piper Bangkok คุณเป็น expertise focus on multi-party and cross-border corporate and commercial litigation and arbitration. He has been involved in violence of high profile and complex dispute in Thailand and beyond. He specialized in insurance and reinsurance dispute. He is a rising and young and very talented arbitration practitioner in Thailand. Welcome, Kun Pin. Before we continue with the discussion, if anyone have any question during the session, please feel free to jump in and drop the question in the chat box. Now, let's start for my first question on this topic to all the panelists. What has been your general experience with physical and virtual hearing for international arbitration recently during the COVID-19 pandemic? You guys have a few minutes to share. Kalis, maybe let's start with you, please. Kalis.
Sure, I'll start this off. And first, I want to say thank you so much for having me here. SIAC-THAC, I'm very grateful, very honored and delighted to be sharing this panel with my fellow panelists and Warathon. Now, my first observation is that arbitration was one of the few sectors that managed to pivot very quickly. The first couple of months after news of the virus broke, you did have a couple of tribunals kind of put off hearings, but quite quickly from maybe about June or July 2020 onwards, you saw that a lot of tribunals were wisening up. They realized that this virus was not going to go away, so they started to hold virtual hearings. And why is it that arbitration managed to pivot so quickly? Because, number one, possibly because holding hearings virtually is not new, right? Pre-COVID, and this was interesting when I found this out. Pre-COVID, approximately 60% of exit hearings, including preliminary hearings, of course, but approximately 60% were already occurring online, virtually, by 2019. The second real important point to me is that institutions were already in the process of updating rules to having electronic filing, and generally, and we'll go into this later in a couple of the other questions, generally a lot of the institutional rules provide for tribunals to have a very wide discretion on procedure, right? Essentially allowing the tribunal to decide how it will conduct proceedings. Now, I'll end with just one more observation on state-to-state disputes and proceedings involving state parties. Now, for proceedings involving state parties, it was generally more difficult, a bit slower to pivot to virtual hearings. And why was that so? It's because states usually and traditionally insisted on more formality. You know, there was sort of more of a chain of command that required these boxes to be ticked. So in state-to-state disputes also, where jurisdiction is founded on treaties, because a lot of these treaties were written a long time ago, in some of them, if you read it, you could almost consider that they imply a requirement for physical hearings. Because when these treaties were written, there was no expectation that hearings would have to be conducted online. So because of that, there was sort of a slower shift. But even nowadays, you know, the WTO, there have been member states coming up to say we support hybrid hearings, virtual hearings, state-to-state disputes. The ICJ, the International Court of Justice itself, has its own guidelines. So I stop here and I leave it back to Warathon or other speakers to chime in.
Thank you, Kalis. I think I've seen some development of the institution and to develop the rule for virtual hearing during the pandemic as well. Thank you for that. Maybe let's hear from Lars. You have any experience during the pandemic about virtual hearing?
Yeah, I mainly have two memories. I had my last physical hearing in February 2020. And I remember that we were laughing when opposing counsel from Eastern Europe said when they go home, they have to quarantine for 2 weeks. And basically in Japan, there was nothing. And so we were like, oh, this is so strange. A month later, we had the same trouble. And then my second memory was already in April as an arbitral tribunal, we held our first virtual hearing. And we had Korean parties, and they said, oh, there's this KCAB protocol on virtual witness testimony. Let's put it to the test. So these are my two memories. And then maybe the third I have is similar to Charis, that in the beginning, everybody was really pushing for a postponement. So was I as a counsel of the respondent, but that soon subsided.
Yeah, thank you. Yeah, the same like Kalish and you mentioned, like at first we all like try to postpone, but now like because of like in Thailand, like you mentioned, like we still have quarantine 14 days, so we cannot postpone anymore. We have like to go on for virtual hearing. Then next, maybe we could hear a little bit from Kabir. Kabir, could you please share your experience?
Sure. Thanks, Varathon. No, I think as Karis said, the issue of virtual hearings was quite controversial. I think at some point of time, much earlier in the COVID situation, I think a lot of people had prepared for physical hearings, and even though virtual hearings were not uncommon, the default was usually physical hearings. I think having said that, we're now probably into 18 or 20 months into the COVID situation in this part of the world, and my sense is that most parties and arbitral tribunals, and certainly the arbitral centers, have already accepted it as a way of life. So I think the position now is when someone suggests a virtual hearing or an arbitrator talks about that, it's almost a given that that's how it's going to proceed. So the controversy in a sense has gone away, but I think what it has shown, and again, what we will talk about in some detail, is that there are challenges associated with having a virtual hearing. It's not always straightforward. And from that perspective, it's given rise to some issues that have challenged, arbitrators, counsel, and in some cases, even the courts. So, lots to talk about for the session.
Yeah, thank you. I think like you mentioned, it's like new normal now. So let's hear from Kun Priyapon.
Thank you, Varathon. From my experiences during the pandemic, I had a case with the physical hearings of the arbitration in Thailand. Because of that, at that time, the case has been, processed in the middle, and 2 or 3 witnesses has already been testified. So the parties agree to, moving forward with the physical hearings, and with some protections has to be, applying. It ended up like, all the parties or, participants to the rooms had to wear double layers of surgical masks. And you find something, quite, challenge for, crossing examination with your mask on. And for the person that have wearing an eyeglass, that they create a lot of foggies on your eyes, and that's quite annoying. So what I mean is, it's not only, to shift to the virtual hearings, but the physical hearings after this day has to be, applied to some measurements if they have to, go on in order to protect from the pandemic and the diseases. Yes.
Yeah. Thank you, Priyapon. I think I got the same experience. A lot of equipment to protect ourselves. Thank you for that. The last one, let's hear from Kun Pin from your experience on during this pandemic.
Yeah, thank you very much, Varathon. So yeah, it's been such a long while that physical hearing for arbitration has been held, at least for me. So most of the hearings nowadays are by way of just go with e-hearings. But then recently we have had a lot of cases where it's a case for hybrid hearing. So counsels that are seated in the country that the arbitration are seated in would have to attend physically, while the foreign counsel will connect into the video call and would attend the hearing in such ways. So aside from e-hearings, we have had a lot of like hybrid hearings as well. So yeah, there are a lot of challenges, particularly technical ones, the ones that ironically within our controls, but when we can never, so it seems like, to control them. So yeah, a lot of those we probably have to deal with, and just to slowly adapt to the way it's supposed to be. So yeah, that's my general experience, and really looking forward to have further discussions around challenges, tips and tricks on how to conduct an e-hearing or virtual hearing.
Thank you, Kun Pin. I just remember like even Thai court normally we will like move very slow, but like Thai court nowadays like still like have like virtual hearing, like Kun Pin mentioned, might be hybrid. So now, thank you, Kun Pin, for your experience, for sharing. Now let's move to next question. What are the advantages and disadvantages of physical and virtual hearings? For this question, maybe let's hear from Kun Pariyapon first. Can you share your thoughts, and then a few more minutes from the floor to share on this, please.
Sure. On this particular topic, I would like to point out the key advantage and the disadvantages of virtual hearings based on my experiences and the discussion with my peers who have been involved in the virtual hearings. The disadvantage of the digital hearings, somehow seems to be the advantage of the benefits of the physical hearings, vice versa. Can I have the slide on, please? So I have listed out the advantage of the virtual hearings for 5 issues. The first one, as everyone knows, the virtual hearing was adopted in order to deal with restrictions on social distancing and travel restriction during the pandemic. Rather than postpone the hearing until it could be held in person hearings, the parties may choose to proceed as virtual hearings in order to move forward with the hearing date and keep the judicial system operating during the pandemic. The second one, it's quite clear that the virtual hearing would eliminate or reduce travel and accommodation costs, especially for the international arbitration case, which the parties, tribunal, and witness are in the different countries. The third one on my list would be the potential for greater availabilities of the hearing dates. Because of relating parties, no need to concern on their traveling or logistic plans. That create more time slot for the parties to get the hearing dates and every parties together. Fourth one is the I think when everyone using the virtual hearing, they have to look at the same screens and will be shared on the same page. So it's maybe less distraction for the advocates or even the tribunals. Last on my list of the advantages of virtual hearing, I think for the smooth running of the virtual hearings, bundles of exhibits need to be well prepared and organized by the counsel, including their teams before the date. Which this thing, forcing the attorney to be, better prepare their case and maybe reach some agreement with the opposing counsel as to exhibits before the hearings to keep the process smooth on that day. Okay, let's flip on the disadvantages. For my list, for disadvantage side, first would be, technical limitations, devices, web cameras, microphone, internet connections, even, lightings would become integral parts of the hearings. Each party must ensure that its electronic equipment and internet connection is of appropriate qualities, and the battery life of the electronic device, is enough for the anticipated durations of the proceedings. Otherwise you will be, easy to distract. The second one is loss of human touch. Someone, including myself, believe that, facial expressions, eye contact, body language, and demeanors can be critical importance in determining the outcome of the case. Most of that is missing in virtual meetings. Counsel may need to adapt their style of advocacy or cross-examine for the visual ones. Things out of the camera lens, cannot be seen. Third one is the more difficult to control witness and assess their creditabilities. I think it's more difficult to the tribunal, to control the virtual hearing rooms, in the same way as they can control in the physical ones. In terms of, who is using the cell phones, who is being talking to whom, who is coaching witness, who is taking notes. The members of the tribunal may not have the same ability to analyze the answers and body language of the witness or experts as during in-person testimony. The virtual setting is a possibility that the witness is being secretly, advised off camera, or maybe, reading documents without knowledge of the tribunal or opposing parties. The fourth one is quite a critical one, is on the confidential matters. The participant may, illegally taking records or, taking screenshots, such as, on the information that being confidential between the parties during the presentations, or when you're submitting the e-bundles to the platform, and then it can be hacked by the hackers. So as different platforms provided different safeguards, the parties need to ensure that any data such as documentary evidence, transcripts, and video can be properly secure and safeguarded during the process. Fifth on my list is the potential for procedural abuse. Because of the virtual hearings, it's made it easier for witness coaching, as I mentioned, taking notes, seeing the documents while you're testifying, giving the statements, or some illegally records, screenshot taking. That can be, all these things can be abused, the procedurals, and very hard to control by the tribunal. Last one, and from my perspective, is one crucial. The crucial ones is that, and also related, to the topics today, is that enforceability of the awards. Because of under, Article 5 of the New York Conventions, an arbitral award may be challenged if a party against whom the award is invoked was otherwise unable to present his case, or where the arbitral procedure was not in accordance with the agreements of the parties, or failing such agreements, was in agreement with the law of the country where the arbitration took place. So this is the key concern that the party need to take into account between before going with the virtual hearings. And it's very important that the party should address any rules and concern in an hearings protocol, maybe similar to the term of reference at the case management conference prior to the hearings, to ensure that there is clarity on what rules would apply and allow arrangements to be made by everyone accordingly. The protocol should be agreed and determined as early in the process as possible, in order to mitigate risks of due process is being challenged. So that is my list.
Yep. Thank you very much. Very beautiful presentation, and from my experience, I found the same. For the poll for virtual hearing, is like to save cost. Normally, like lawyer file the first card, business card, but now we don't pay that for that ticket. And also for the con, I faced some from my own experience. My internet went down during the virtual hearing. So that's my experience. So on the panel, anyone would like to add a little bit your experience, pro and con on virtual hearing on this? Feel free to jump in.
Yeah, I mean, I can add a bit. I certainly agree with Prayopon's recommendation that before, beginning any commencing arbitration or during that part, you probably have to agree a procedural order, or have some sort of an agreement that the tribunal would have the discretion to allow virtual hearing, because otherwise, in a very extremely contentious cases where, parties barely are able to agree upon anything, like, so to speak. It's just so difficult to get them to agree upon anything. And personally, I have experienced that. And it's just like, even just the constitution of tribunal take over 1 year, 1 or 2 years, and still ongoing. Yeah, probably a lot of panelists would relate to that aspects. So yeah, it's just difficult. So like a potential point of challenge would be, as Priyapon mentioned and Varathon has emphasized, is the integrity of witness trial, that it could be jeopardized by the fact that, potentially there could be someone coaching the witness. And if that point is being challenged, it's just interesting to see. Like, personally have no experience on that, but just a query raised, just gonna throw it out there. And it's a point to be answered with time, that if somehow there's a challenge based on the integrity of e-witness trial or e-witness hearing in arbitration, with the court of where the award would be enforced, entertain such sort of challenge. Yeah, just want to raise the question out there.
Yeah, thank you. We can discuss in detail in later question as well. So just like 1 or 2 minutes left. So anyone to share, add a little bit on explain on this question, disadvantages and advantages.
Yeah, I mean, Varathon, I could say 2 points. I think one is on the issue about what I would call witness security. I think that was a good point that was raised in terms of, who is with the witness, what is the witness reading, what does he have access to, etc. Now, I think many of us would remember that in sort of what I call the good old days, even though we did a virtual hearing, we would insist that the witness turn up in the, our law firm. If it was an international firm, we'd go to an office overseas, and one of our juniors would sit there with him, just to ensure that, in a meeting room that, he only had access to the bundles and there wasn't anything else. Now people are allowed to take hearings from their homes, right? So we had a case recently where, the witness was under cross-examination, and then, it got quite heated, and then suddenly there was this hand that appeared that gave him a tissue paper. And then we were wondering, okay, who's in the room with you? And so then and then the tribunal said, okay, can you please tell us who's in the room with you? Why is this person there? And so it's not only that, but it's also confidentiality, right? Because technically it's a confidential proceeding. So you had that. So it's actually a real life issue. I mean, it does occur. I mean, the other point to also, I think, bear in mind is on the cross-examination. And I think this probably impacts more of the common law lawyers, I would call us, the ones who like to do, long and detailed cross-examinations. I think that style of advocacy probably lends itself better to a physical interaction. And a lot of, traditional barristers, for example, will say we need to confront the witness, and, we need to see the witness and his. So again, doing that in a virtual setting comes with challenges. So, those are just 2 points I thought I'd share.
Yeah, agree. Like for the civil practitioner as well, if you want long like trial, it's difficult now in virtual. Okay, thank you. Maybe because of the time, we move next question on my list. Move on. This question for Kalis. What has your experience been with like general institution rules regarding the right to physical hearing over the virtual hearing once, or vice versa?
So most major institutional rules do support virtual hearings, and what it comes down to is the discretion of the tribunal to conduct proceedings as it deems fit, right? And the SIAC-THAC and ICC rules are in line with this general position. SIC Rule 19, tribunal shall conduct the arbitration in such manner as it considers appropriate. THAC rules, Article 38, arbitral tribunal has the power to conduct the arbitral proceedings as appropriate. And I like that later on, if you read down in that article, there's another as appropriate. So very clearly demarcating the tribunal's discretion. ICC rules, arbitral tribunal shall adopt such procedure measures as it considers appropriate as well. So I think what this comes down to in practice is what a very senior arbitrator shared with me when I first started sitting as an arbitrator. She said, well, as the arbitrator, you are the boss. And these rules reflect that, right? The arbitrator gets to decide. But I have heard of an arbitration institution from around Southeast Asia, which I will not name, that did not allow a tribunal to conduct a virtual hearing when one party objected. And that led to quite a lot of frustration on the part of the arbitrators who even considered resigning, because the arbitral proceedings were then paralyzed and stuck for a very long time. And this is reality, which I think someone else will pick up in the next question. There is a handful of jurisdictions where there could arguably be a right to a physical hearing. There's a whole range, but there's a handful whereby you could argue that there is such a right. And therefore, that means that you cannot proceed with a virtual hearing over one party's objection. So institutional rules is one thing, but you also have to consider the law of the seat. Now, what is useful is some guidance notes, and many of you would have come across these, right? The ICC is a long name, the ICC guidance note on possible measures aimed at mitigating the effects of the COVID-19 pandemic. The SIAC guide on taking your arbitration remote. So what I will say is very helpful is that these guidance notes have sample virtual hearing protocols, checklists, and these are useful whether you're counsel or arbitrator, right? I think I can pause there, but my last point is to, I think, say, we need to bear in mind that in this sort of situation, the best outcome is that parties agree. But what parties agree to is also sometimes, it can also vary, right? They might agree to a virtual hearing, but once you get down to the virtual hearing protocol, that's where the rubber hits the road. And this is a point that was raised by Kunprin Warathon just now, that, what happens if your internet goes down? And this is a live issue that we'll face, right? One party says, well, if the internet goes down, we're going to carry on with a hearing on telephone conference. Is that acceptable to you as counsel, to you as a party, right? So these are still live issues that you have to work through when you're actually agreeing on the virtual hearing protocol.
Oh, thank you very much, Kalish. That's really interesting, and think that the institution maybe in the future maybe provide the rule in detail. That maybe I might help. So, and any on the panelists who would like to jump in and share, you explain on this topic about general institution rule regarding the line of the physical hearing over the virtual or vice versa. Anyone? Yeah.
Maybe I can. So what I've noticed is now the typical arbitration practitioner habit starts kicking in, that you start collecting all the procedural orders from various tribunals and kind of then recycling them and trying to adjust to your case. So it's become an interesting game where, similar to procedural order number 1, you pick the best provisions and you compare. So I think maybe over time there will be kind of one standard order emerging. But of course, at the moment, still the hearings as such, or the arbitration as such, are so different that it might be difficult to come to a landing on that. But I just found, so I've definitely personally started collecting and then always checking and proposing to the opposing counsel. This is how about this?
Yeah, agree with like Kalish and La mentioned, like maybe in the future, like when we can have the masterpiece after like sometime 1 year, 2 years after our experience about like advantages and disadvantages. That might be. So maybe we come to discuss for my next question to Kunpin first, and Arthur can share. Are there any specific local laws in your practice or your jurisdiction regarding the line of physical hearing over the virtual ones or vice versa? And do the party involved need to consent in the virtual hearing? Maybe let's hear from Kunpin first, and any other panelists can join. Yeah.
All right, thank you very much, Raton. So my practice is primarily based in Thailand. So I'll be commenting on particularly based on Thai law. So under Thai procedural law, and with respect to the newly recently issued notifications, hearings are by default physical hearing, unless otherwise requested by the parties. So in that sense, right, there is no specific law that entitles or affirms the parties to physical hearings, because by default, hearings are expected to be ran physically. in person. I mean, yeah. So in a Thai court proceedings, there are generally two types of hearings. So the first type being the trial hearings, where witnesses would appear and then testify, and then there's cross-examination and re-examination. And then the second type of hearing being non-trial hearings. So those are, for example, case management hearings, judgment pronouncement hearing, or case determination issues hearing, for example. So those are non-trial hearings. So since before COVID-19, there has already been a law to allow parties to conduct witness trial hearing by electronic means, or particularly video conference, just to translate by Thai to English. And there is an extremely stringent guideline for that in practice, such as witnesses have to appear in the consulate of a foreign countries in order to have the consulate officials, affirm that that person is really the person he or she claims to be. And yeah, that has caused a lot of challenge in practice, because you have to coordinate with the embassy or the consulate, and not taking into account the time differences, opening hours, because Thai courts for some reason generally schedule witness trials on Monday. Yeah, and particularly in the morning, like 9:30 a.m. or perhaps in the afternoon. So that has been a challenge. And for non-trial hearings before COVID, there is no such regulations that allows e-hearings or video conferences. However, given the recent COVID-19 circumstance, there has been a lot of backlog cases that has to be postponed. And because of that, a lot of courts in Thailand has recently issued a notification that allows non-trial hearings to be conducted via electronic means, but of course, subject to the court's permission. So in practice, prior to the hearing, one party or both parties can or have the right to request the court for such non-trial hearing to be conducted via electronic means, and the court would exercise its discretion to then allows or to give permission for that hearing to be conducted via electronic means. So most of my hearings nowadays, particularly for the last 6 months, has all been e-hearings, aside from witness trials. But I'll come to that in a bit. So yeah, that has been the recent trend in Thailand. So in practice, right? To answer the question, is there a right to is the consent of the other parties required for hearings to be conducted virtually? In practice, I'm inclined to say no, because at the end of the day, the court retains the full discretion whether or not Thai courts, whether or not to allow for such hearing to be conducted virtually. So, but in practice, if there is a party challenging for the hearing to be conducted virtually, the court would more or less listen, and if there's a sound argument towards it, then the court would decline the other party's request for virtual hearing, and then proceed with physical hearing instead. That has been a trend in multiple of my cases in multiple Thai courts. But recently, this came as a surprise to me as well. So our witness is based abroad. So then we requested the court to conduct a witness trial hearing via electronic means. So as I have mentioned earlier, in practice, he or she has to go to the consulate or the embassy to have, officials testify, or like affirm or attest to the identity. But now the court just say, oh, it's totally fine. Witness trial, it's all right. You guys can go to your law firm abroad and have a lawyer, like a notary public, to attest to the identity. So there has been an extreme, I would say, shift in the trend of Thai courts nowadays to allows for more of a flexible, if I may, stance towards virtual hearing. So it's not as stringent as before, but then at the end of the day, Thai courts still retain the ultimate discretion to allow or to disallow virtual hearings. And whether or not the other parties would have the right to challenge virtual hearing, I would say yes, but then the court would still retain the ultimate discretion. So, but then I would say 70 to 80%, the court would listen to the other parties, whether or not the other parties are inclined for the hearings to be conducted, both trial and non-trial hearings to be conducted virtually. So that has been a really interesting trend. So in the beginning, we were quite excited to have the first, one of the first hearings conducted virtually. But then as time goes by, 10 10 plus hearings to be conducted virtually. So there's not much to do. And then, you can just relax at home, because a lot of Thai courts proceedings has always been about waiting and waiting and waiting for the courts to come by and for, procedures order to be issued, which that can take like a lot of waiting. So we can just turn off our camera and show. But that has been the recent trends in Thailand. And, whether or not there's a right to physical hearing in Thailand, or whether there is a right to challenge a virtual hearing in Thailand, that would be it for me, Raton.
Yeah, thank you, Kun Pin. We are in Thai court, normally in Thailand, it depends on the court discussion, mostly on that. Thank you. Maybe let's hear from other jurisdiction. Anyone who would like to share on other jurisdiction?
I'll quickly jump in. A
Yeah.
lot of you would have heard of the ICA report on whether or not a right to a physical hearing exists. And as I foreshadowed just now, there is a range, right? So there are a couple of countries whereby there's arguably a need for agreement. Otherwise, you can't have a virtual hearing, right? India, Ecuador. And then on the other end of the spectrum, you have places like the UAE, where the law expressly gives arbitrators the right, the discretion to hold remote hearings. Singapore, Kabir, were you going to jump in on Singapore? I'm happy to let you jump in on Singapore if you're going to.
No, go ahead. I think the answer is quite straightforward for Singapore.
Okay,
that's fine.
so Singapore, there's no right to a physical hearing. We are model law jurisdiction with limited modifications to the model law. There is a case called China Machine against Jaguar Energy, and basically it says there that a party's right to the full opportunity to present your case is not unlimited. So you sort of in line with that, you don't need to feel bound to have a physical hearing. Yeah.
Oh, thank you. I have one experience, maybe true or not true. Maybe I ask last to address this. I heard that when I have my Japanese client, we want like Japanese client in Tokyo to testify in the Thai court, and because of like quarantine, he or she cannot fly to Thailand. Then we ask them to have a virtual hearing for the Thai court in Tokyo. But I heard that there is some advice whether like the witness can testify in Tokyo because of the sovereignty or anything. I'm not sure, but maybe like let's hear a little bit from La. Do you have any explain, or do you know about that particular issue and come up in my mind?
No, Japanese courts are very strict, or Japanese laws are very strict on witnesses testifying for courts abroad. So I had the same issue recently for an American court proceeding. And basically the witness has to go to the consulate or the embassy, with the interesting point being that the American consulate or embassy was basically the hearing room for those purposes just closed indefinitely. So basically you cannot take witness testimony. You would have to fly the witness to the US. So that's an issue. Maybe just to give you the overview over Japan, when it comes to arbitration, and that's also in the ICA report, there is no right to a physical hearing. So basically it's at the discretion of the arbitral tribunal, and Japanese courts themselves, they closed down for about 2 months during the pandemic last year, and then reopened with a modification. And so in a Japanese court proceeding, what we now had to do, the kickoff hearing and the closing hearing, they have to be in person, but everything in between can be done virtually, which is quite comfortable, especially if the majority of the lawyers is basically in Tokyo, and then you have to go to a local court somewhere else. That's quite comfortable. Maybe just one point, I agree with Charis that, of course, it is always a bit dangerous, and you need to kind of come to an arbitration-friendly jurisdictions, because courts should not apply their understanding of what's happening under their own procedural laws to an international arbitration. And so that can be sometimes a bit difficult.
Okay, thank you very much. Then move on the next question on related topic. In that case, if the party does not consent to it, can we challenge the tribunal order for like, the virtual hearing? If yes, how is that done? Maybe let's hear from Kabir. And then maybe let's get back to Lars on arbitrator perspective on that. Kabir, could you please share your experience on this?
Thanks for that. No, I think this is obviously a live issue for many people. And again, we all know that, when you are the losing party in particular, you sometimes want to explore all of your options in terms of how you might be able to challenge an award. So this is one of those, I think, in the arsenal that you talk about. So let me sort of spend the next sort of 3 or 4 minutes giving you a couple of thoughts that we can then perhaps discuss more broadly as a group. So I think the overarching observation is that in most of the sort of key arbitral centers, I would call it, it's generally difficult to challenge a tribunal's order for virtual hearing as a matter of principle. So, I mean, assuming the parties have been given an adequate opportunity to be heard, there's no otherwise breach of natural justice. I think just because you have a hearing virtually itself won't put you in a better position to challenge that. So I think that's the broad point. Of course, I would have to caveat that by saying, and again, Karis, mentioned the ICA report on the spectrum. And again, the practice is obviously not uniform across the globe. There are still some countries which hold the right to a physical hearing very dear. And from that perspective, you will have to take that into account. But generally speaking, as I said, for the major arbitral centers, you should be all right. Obviously, you need to look at the specific facts and what, the various sort of rules that you're going to be bound by will say. So from that perspective, you generally tend to look at the applicable procedural law. So what is the law of the arbitral seat, whether that contains any express provision saying that you need to meet in person, or whether there's a need for consent to go into a virtual hearing, etc. Any specific institutional rules. Now, we've talked about some of the major institutional rules, ICC, SIAC, and the like, that have more or less got express provisions, making it clear that the arbitral tribunal has a discretion. And in many cases, because of the COVID situation, they've gone ahead and issued protocols and guidance notes, expressly on the issue of virtual hearings, again, to make absolutely clear that, virtual hearings are permitted under their rules. And then, of course, the last one you want to consider is any specific sort of agreement between the parties. So this is, whether there's anything in the arbitral agreement, the arbitration agreement rather itself, or in any procedural order. Now, generally, you don't tend to find the right of a physical hearing specifically documented in an arbitration agreement. But having said that, there are some parties who prefer more detail and prefer to leave less of it to an institution. So we have seen some, clauses which actually say the arbitral proceeding shall, shall take place in person in this country, for example, right? So in that situation, I think you might run into an issue potentially of the arbitration agreement itself specifically requiring it. And then, of course, many of us who are then familiar with the setting aside grounds will know that that might give you a basis for a challenge if you breach that. So that sort of takes care of the major sort of points that you want to talk about. Generally, as I said, arbitral tribunals do have a broad discretion under many of the well-known arbitral institutional rules. So in a sense, that's enough generally to take care of the point. And so it will be difficult to launch an objection. But we have seen a few cases, it's probably worth me mentioning one or two, where actually, even when the matter has been taken up to the courts have disagreed. So again, in my research, we sort of turned out two cases that I thought might be worth mentioning. One was a case in the Austrian Supreme Court, I understand, sometime in July 2020. It was a Vienna International Arbitration Center arbitration seated in Vienna, Australia. Now, the arbitral proceedings had been pending since 2017, following a case management conference in March and April last year. So this is sort of beginning of COVID. The tribunal decided to proceed with a one-day evidentiary hearing on 15th of April by way of video conference. Now, this was done despite the objections of the respondents in the arbitration and their position that they were entitled to an in-person hearing to be held at a later time. Now, unsurprisingly, the respondents didn't succeed. They then applied to set aside and to rather challenge the arbitral tribunal's decision. Now, the challenge was unsuccessful, and the Supreme Court rejected the appeal. Broadly speaking, the courts found that really there was not any breach by the tribunal of the rules of natural justice or the duty to treat parties fairly. Among other things, the court did observe that, very much so in international arbitration, video conferencing technology is widely used, not just in arbitration, but also in judicial proceedings. And again, we've talked about the various courts in the world that have all adopted video conferencing and virtual hearings. And therefore, from the perspective in Austria, that wasn't a very odd procedure or something that one can be criticized for. Second, and this was important, is that actually the time difference which caused the respondents' counsel and the witness to start at 6 a.m. in Los Angeles was a disadvantage accepted by the respondents. And it wasn't really a problem of the virtual hearing. So one of the arguments they raised was, oh, because we had to start at 6 o'clock in the morning, we didn't have. Now, again, by concluding the arbitration agreement, providing for the VIAC arbitration seated in Vienna, the courts held that the respondents had actually accepted that there would be travel, there would be time differences, etc. And so this is really par for the course, right? That was the message. And then there were also certain interesting allegations, I mentioned this earlier, of witness tampering, all right, where you would have, potential witness tampering going on. And the court, I think, was dismissive of that in saying, look, you could also tamper with a witness if you wanted to in a physical hearing. So that wasn't really just something in a virtual hearing. And again, many virtual hearings now allow for mitigation measures, like making sure the witness is in a secure room or in a secure platform, etc. So, there were ways to get around it. So at the end of the day, I think the basic notion there was that this wasn't sufficient. There was an Australian case, again, if I have maybe just another minute worth mentioning. It was an earlier case though in 2016. And this was an Australian seated arbitration under the Untitled arbitration rules of 2010. Again, Sino-Dragon had applied to set aside the final award on the basis that the evidence of two witnesses called, was actually hindered by technical difficulties. So they basically said, look, there was video conference, there were technical difficulties, and that actually prejudiced our witness and the evidence. Now, the final award actually did take note of the technical difficulties, citing in particular the fact that the video conferencing tool didn't work and the evidence was in fact given by Skype. There was a split format needed to be adopted, i.e. the video was actually transmitted via computer while a separate telephone link was used. So, you had actually the picture coming across the screen and then having to turn on your phone. And then the witness had not been given any of the relevant documents and therefore he couldn't be directed to them. So there was a bit of chaos in the hearing itself. And unfortunately, the interpreter itself wasn't qualified. So the court actually did, or the tribunal actually did notice these observations. And it even said there appeared to be someone unknown present in the room with the witness. Again, one of the points I mentioned earlier. So again, these are real life issues that they do arise, but I think that the short point is at the end of the day, despite the party saying that, look, it was not given an opportunity to present its case, it wasn't treated fairly, it was a breach of natural justice, public policy, etc. So all of these arguments were run. The court ultimately dismissed the setting aside application. And so they said the mode of evidence by video conference, even though it's less than ideal in that case, doesn't in and of itself produce any unfairness or real practical prejudice. So again, I think the short point was the court actually said, beyond just having it on a video conference, you need to show that you were actually prejudiced and there was actually harm that had befallen you. And so unless you could do that, that was going to be tough. And then even putting aside the fact that, the party itself had chosen the mode on which to give evidence, the technical difficulties did not have a material impact and didn't rise to the level of breaching the right to be heard. So here it wasn't a case of an objection, it was a case where the technology failed, or rather was poor, I would say. And from that perspective, the challenge was so again the courts, I think, tend to be quite pragmatic about these things in many of the countries. I want to highlight one case though, sorry, Warathon, I'm overstepping, but there was a Swiss case where we do understand that I think in relation to some judicial proceedings, there was a successful challenge, right? And so there was a Swiss federal tribunal that upheld an appeal of a party who objected to the lower court's order of virtual hearing, in state court proceedings. So again, in a court situation, it might be different. So again, just putting these things out there so that we can have some thoughts across the panel.
Yeah, thank you, Kabir. That's very interesting, and you might already answer the first question from the fore already, because they want to hear about the real case set that you already mentioned. Thank you very much on that. So last, could you add a little bit on arbitrator perspective, or you explain on this?
Yeah, so maybe from the arbitrator perspective, I mean, I fully agree with what Kabir said. And we had this case very early on in 2020 that was calling for a virtual hearing. And so, of course, we were really hesitant when respondents said, we don't want to do this. And we felt like we have the discretion to basically overrule that. But nevertheless, we want to be careful. And so what we did is, and fortunately, we had very professional counsel on both sides. We, as a tribunal, made it very clear that if respondent doesn't agree, we would decide in favor of a virtual hearing. But that then alone was sufficient for respondent to basically cave in and say, okay, we agree. And that made us feel much more comfortable, because then at least that particular issue could not be raised to challenge the award.
Yeah, I agree on that, and like Chris already mentioned at the beginning, I agree on that. Thank you. And another question on you. Can you also share what are the possible issues that may arise with virtual hearing, and with virtual hearing, what are the issues we should be aware of?
Sure. The issues we should be aware of. I thought about how to approach this, and felt that probably by now everything would have been said by my very smart colleagues. And so I thought maybe I'll just repackage it a little bit, and not maybe talking about it like a new normal, but as a revolution. And that brought me to thinking about the French Revolution and the motto, Liberté, Égalité, Fraternité. And I thought, why don't I apply this to virtual hearings? And I came up with legality, equality, technology. And if we run through that, of course, legality, we've just discussed it, and Kabir made this quite clear. We really need to think about, and Charis as well, when we run a virtual hearing, is this going to be a problem at the seat of the arbitration? I think Victor in the chat also asked whether we have to take care at the place of enforcement. I think that's a very good consideration. Of course, probably more so for counsel. Of course, tribunals also have the duty to render enforceable awards, but they probably will not know at the time they decide where a party wants to enforce. But then we're basically back when exercising the discretion. We're basically back to the issue, well, if both parties agree to a virtual hearing, it's probably going to be no problem, unless there's a seat of the arbitration that says, well, it has to be always in person. If one party agrees, then we're back to the applicable arbitration rules and the tribunal's discretion. And of course, if both parties say we don't want a virtual hearing, I would not recommend to a tribunal to overrule that. So basically, that's on the point of legality, as I call it. On equality, I think everybody dealing with arbitration knows about the equal treatment of parties, and Kun Payapol also said, I mean, it's also a due process issue. Maybe just 3 observations. I think one thing that is, in a sense, also self-evident is that there is no right to equality of technical means. And you can see that I'm the only one too stupid to have a virtual background. I don't have a microphone as nice as Kun Prin, but nobody would say, well, this is like totally unequal. So I mean, parties can hire very.
And you look even better without a virtual background. That's the key, so it's unequal against us.
Yeah. So so we all agree that's not unequal. But 2 issues I think that might be discussed in the future a bit more, and Kabir just mentioned it, and I think that's not so easy. When it comes to time differences, if you have a one-day hearing in Vienna and somebody has to get up at 6 o'clock in the morning, probably it's not a problem. But if you have a two-week hearing and basically only one party gets to benefit from the right time zone because they're in the same time zone as the arbitral tribunal, I think that's where we reach a certain gray area that I think needs to still be worked out. I think that's an issue that hasn't been discussed sufficiently. The second point is, and that has been raised by Kun Pariapol, and Kun Prin, is hybrid hearings. Because again, it makes me somewhat uncomfortable if one party is sitting in the same room as the arbitral tribunal and the other party has to dial in. there are dynamics in the same hearing room that it's not fair if only one party sits together with the arbitral tribunal. Again, does it rise immediately to a complaint about inequality? Probably not, but these are issues I think they still need to be discussed more and need to be worked out. So moving on to the third, the technology. And again, I think some of the things are obvious, but I think we need to make sure when we use technology that we preserve the basic equality between the parties. And we just heard it. You can't have a witness drop off the video conference every time the witness gets a difficult question, then there's obviously something wrong. If a party loses the internet connection and the tribunal just simply continues the hearing, that's not going to be good for the award. So of course that's something we need to make sure. In a sense, the workability of the technology, I think everybody now has started doing those test runs. In the very beginning, they were not necessarily common. So now everybody does them kind of as a matter of course, but I think that's a very good thing to do. And I had one or two test runs where we basically had to say, no, you cannot dial in all from that one room. You have to be separate. And we really had to shift things. So I think these things are important. And final point, I think, on technology is, and Kun Pariapol already mentioned it, I think cybersecurity, confidentiality, it's really something that needs to be worked out more as well. But I have to say, we all heard the stories of senior arbitrators leaving their laptops in the airport after flying home from an in-person hearing. I attended a hearing where the co-arbitrator's laptop was stolen in a break in an in-person hearing. So I don't think that's a pure issue of virtual hearings. I think that's generally something we need to think about more. So with those revolutionary thoughts, I'll leave it.
Thank you. Thank you. That's very interesting. I have one experience, like not the virtual, but maybe compared to virtual hearing, that witness always asked to go to the toilet in every 10 minutes. So like Javier mentioned, maybe they need some help in the toilet or anything like that. So before we move to a last question, you have anyone here to add on what La just mentioned? Yeah.
I think maybe I just want to comment on the time zone issue. I think that, Lars, you raised a very good point. And, recently we had a case within our firm where, because of the location of the arbitrators, one was in the Middle East, one was in Canada. And unfortunately, us in APEC tend to get the short end of the stick. And so we had to start off, hearing at about 2 p.m. and end at about 10 or 11 p.m. each day. So it was almost like, having jet lag on the ground in Singapore, right, where you started. So you're right. I mean, people can do it reasonably well for 1, 2, 3 days, but if it's a long 2-3 week hearing, then it does take its toll, and then the question of whether unfairness sets in. So I think that is a very, very good practical issue that people need to think about.
Okay. Thank you, La and Kabir. So we come to the last question on my list for all of you to share on the question. Finally, what are your final recommendations for international arbitration hearing post-COVID-19? What the hearing would be look like, or international arbitration would be look like in your experience, in your eyes? This question come to everyone. Maybe start with Kun Pin first. Thank you.
Yeah, thank you very much, Raton. So I think overall, like the message that I'm hearing, there's a sort of like a concerted response that hearings and a lot of things have to be based upon parties' agreement. And if the parties are not in agreement as to the method or the means of the hearing, then might as well not conduct it in such way. So I think a lot of things to avoid problems, probably the safest way is to reach an agreement on protocols, have a fixed or something along those lines in agreement. And a lot of issues that have been touched upon but may not have been expanded is the technical issues of things, right? So to speak, like ever since the Thai courts has changed their stance on conducting a lot more e-hearings, I have invested in a webcam. So generally laptop webcams are 2 pixels. So my webcam is over 10 pixels. So it's at least like 5 times more clearer. So in that sense, there, like the court could, the court could see my, because it's been mentioned in Bariapon's slide as well that, the micro expressions, a lot of things are lost along the ways of virtual hearings. So I try our best to preserve that, or the advocacy styles, by having a better camera, better internet connection, and hopefully a better microphone as well. Because it seems thanks, Lois. Yeah, and thanks for calling me out as well. So yeah, like I discovered that a lot of times arbitrators or courts or councils would listen to you more, especially when two sides are speaking at the same time, but you have a better voice quality that and so it tends to stand out, not necessarily a better voice per se, but a better voice quality. So like a lot of things are within our control as counsel, or so might as well have it prepared in a way. So yeah, I think a lot of people have seen a viral video of a counsel leaving a cat filter on. Yeah, so so that is a very good learning lesson. Or in someone left their camera open while doing all kind of things. So yeah, that's just not the things that you're supposed to be doing. So yeah, that have to also have to be careful on that front as well. But yeah, I think that's it from me,ครับคุณราธร.
Thank you very much. That was very interesting. Now maybe Kun Paripon to share after like really beautiful presentation and to summarize what do you think about the post-COVID look like with Paripon?
Yes, I think everyone here is agree that the virtual hearing is the alternative methods that keep the proceeding going during this pandemic. If you're waiting for the physical hearings to be occurred for the international arbitrations, I could not imagine what period of time that we have to wait, maybe next years. So the justice cannot be wait that long. I think the institutional rulings will take an integral part on these virtual hearings. The institutions of arbitrations need to adapt or creating the details of the protocols in order to deal with all of the issues that has been raised during the past virtual hearings, and be addressing on the rulings in order for the parties to be more convenient and less issues to be in the agreement, and also less work for the tribunals as well. So not only the virtual hearings, as we are in the new normal, as I mentioned before earlier, the physical hearings has to be adjust, maybe some distance between the parties has to be extended, and if you can see, some plastic box has to be created in the meeting rooms in order to prevent spreading some aerosol, something like this. So we are in the eras that changing the methods of hearings, and all of this needs to be addressed.
Thank you, Kun Pirapon. I agree that like not only the virtual hearing but also the physical hearing. For example, the canteen in the court, maybe in the Thai court, have to be built more bigger. We cannot like in that canteen. Maybe next, Kabir, you have like anything about about the post-COVID?
Well, I think the situation of COVID is long of, I think, well, so I should say far from over in many jurisdictions. And I think whatever practices that we've inherited, whether we want it or not, as a result of COVID, I think will probably make their way into the international arbitration landscape in some shape of permanent form. So I don't think virtual hearings will go away just because COVID eventually goes away. I think in particular, many clients have seen the benefits to their bottom line in terms of fees for not having to pay for their lawyers, as you said, Varathon, to travel on expensive flights across the world, and to have to pay arbitrators fees on business and first class, from different parts of the world. So I think there have been benefits there that when people have tasted the benefits. So that's going to happen. But I think I do see a return to physical hearings proportionately. So in a sense, I think where possible, many counsel, I think, might still recommend physical hearings. And if the travel is short and if the duration and the costs are not significantly more, I do think that some of the benefits of a physical hearing still might justify that happening. So again, it's a lot of future sort of telling, a lot of looking down the road and into the hourglass, but let's see.
Thank you. Maybe hear from Lars.
I'm a bit of two minds. I mean, I can't wait to come to Singapore or Bangkok again. So in that sense, I definitely advocate for in-person hearings. I also think when you sit as an arbitral tribunal, having the arbitrators discuss in the break and in person and having a dinner is a totally different thing than having a WhatsApp channel while the cross-examination is going on. On the other hand, and this might be a bit controversial, and you have to take it with a grain of salt because I'm a civil law lawyer, I feel like the fear of witness tampering and of not having an effective cross-examination is a bit overblown, at least again from a civil law perspective. Very often, in my experiences, I haven't had kind of witnesses being tampered with. At least they were looking in the camera, they were busy with the cross-examination, and they would not have had time to basically take messages or discuss with somebody else because their face is on camera. So actually my experiences, and maybe I just had the easy cases only, were actually quite good. So I could see that even for witness testimony, there might be in the future more virtual hearings than we might think.
Thank you. That's possible. Last but not least, Kalis, what do you think on this?
Thank you, Kuharathon. So I'm going to pick up a couple of points from what has been said before, right? I do think that given the convenience, it's hard for us to go back to full physical hearings only. I do think that merits hearings, for the most part, people will still prefer physical hearings. But other than that, the smaller procedural ones, the preliminary meetings, you will increasingly see tribunals just say, we're going to go with virtual hearings. Now, what do I think? I think it comes down to education and adaptation. Why do I say education? Many of us would have heard of the SOE protocol, the virtual Vienna protocol. And it's, for us as counsel, it's about us understanding increasingly the pros and cons of physical hearings and virtual hearings. It's being familiar with what can and cannot be effective when we conduct a hearing virtually. And then number two, why do I say adaptation? Because perhaps this is the opportunity for us to explore new procedural structures. And here I'm going to give a bit of a shout out to Kevin Kim's Gangnam Principles, if you have heard of it. Basically, one of the ideas he's advocating is draw from the experience of civil law procedures, have a greater number of shorter hearings. You have an initial review hearing, you have an intermediate hearing, then you have a final evidentiary hearing. And even for me as a common lawyer, I see the benefits of that because you're more focused on the issues. Counsel and tribunal are engaged earlier on, and you carry that through all the way to the final award. It's also important for us as counsel, I think, to more effectively advocate our clients' positions at virtual hearings, right? So for example, I mean, this is what Lars was talking about, you know, sort of how do you coordinate with messaging and looking at the witness. And for me, over time, I've adapted somewhat and decided, well, 3 screens works best for me. One to look at the live transcript, one to stare at the witness as best as I can, stare him down, and one to communicate with my team, because obviously I can't pass messages across the table like we used to do in physical hearings, right? Even basic things like colors, what are we wearing? If you wear stripes or you wear very bold patterns, will they be, will they be distracting? Will they cause strobing? These are things we used to teach our students in moot court, but these are also practical advice that we need to take for ourselves, right? So finally, I think I'll just say, if we adapt well, the use of virtual hearings can in fact be more cost efficient, more effective, and ultimately promote expeditious and fair resolution of disputes. And I leave that thought with you.
Thank you very much. That's really interesting. So thank you all for your input. We have some time, a few minutes, just 2 minutes for the question from the audience. The first question, like, would we instead ask, is there any right to the virtual hearing? This may be considered by relying on Article 18 model law, where each party shall be given a full opportunity of presenting their case coupled with like the hardship or travel etc. Anyone would like to share response to this question?
Well, I made the point earlier, this goes back to the equality of means. So I think it's very hard to argue. I don't have the money to travel, so I need a physical, virtual hearing. I think as long as you can present your case, I don't think that really speaks for either one of those.
Thank you. And the last one about we mentioned a lot about the tempering the witness. Victor Smith asked, surely the case has potential for witness coaching or tempering occur during the drafting of the witness statement as well. Anyone would like to share?
I think that some of the normal procedures for preparing witness before taking a stance, but what are we dealing in this particular issue is that on the cross examination and how to deal with the cross examinations. The witness can also be coached out of the cameras. That is the things that we are discussing on this.
You can look in witness eye. They're not on the camera. They will see. Look to find the answer behind the screen. So thank you all. Thank you very much for the interesting topic from you all, from the panelists today. It's really nice to hear from your experience and your thoughts, which are really useful and really interesting. Also, I would like to thank our attendees who joined with us today. I hope this discussion have given you some new insight and physical or virtual hearing in arbitration proceeding. And last but not least, I also would like to thank SIAC and THAC for making this webinar happen. Till we meet again, I will over back to Suen.
Thank you very much, Varathon. Thank you to all speakers for the very insightful and interesting session. And thank you to all attendees for joining us today for the SIAC-THAC webinar. We hope to see you again at our future events. Have a lovely evening and please stay safe, everyone. Bye.